Good.
Again, Your Honor, Kimberly Stout on behalf of Mr. Hamby. Would you state your name for the record, sir?
Gabriel Hamby.
Okay. What are we doing?
Thank you, Your Honor. We're going to set this for a preliminary exam. I have the police report. I still probably
Right away, this hearing feels serious. The defense isn't trying to wrap this up quickly. They want a preliminary exam, meaning the prosecution now has to show enough evidence for the case to continue. That usually means both sides know this could turn into a major courtroom battle.
probably some more discovery out there that I'll receive, but I am pretty certain this needs to be heard. And I also wanted to argue bond. Thank you.
Media requested yesterday. I've not received media yet for this file. Divided for the camera, but I will call.
Do we know when we'll get it?
I guess if I request yesterday, probably see it tomorrow.
Okay, there won't be an adjournment if it's not received, if I'm gonna set it. People have their witness, would you? I can set it for the 12th. Does that work for you, counsel, or the 19th?
Would that be in the morning on the 12th, Your Honor? Oh, I'm in trial. I'm sorry. The 19th.
Probably with Goldstein and Willingbury. Anyway. 19th.
I wish I had co-counsel in their case. What time, Your Honor? 9 o'clock?
Everything's in the morning.
Okay, very good.
All right, discovery's complete. Will people have their witnesses available that day? All right. Then I will set preliminary examination in this matter for May 19th, 2026, 9 a.m. That's before me.
Wonderful. Argue bond, Your Honor.
You may.
Thank you. Judge, I submitted a motion.
Listen carefully to how the defense builds sympathy here. Young age, no criminal record, stable job at Ford, owns a home, supportive family in court. This is a classic strategy during bond arguments. Paint the defendant as someone with too much to lose to run or reoffend.
I hope you had an opportunity to look at it.
Yeah.
There was attachments. My client is only 20 years old. He's very young and he's HIDA eligible if this court eventually or becomes a matter for the court. He has no record at all. He has a job at Ford, very good job, which is hard to get. He's going to lose it because he's been in for a while now. He also owns a home, which I provided proof. I think of great significance is his mother, his stepfather, his grandmother, and his grandfather are all here in the courtroom. They've been available the whole time to me and are very concerned about him. And we'd like to get him some therapy too. And I've already talked to Dr. Tara Abramsky, who's a forensic psychologist, clinical psychologist, quite well known, to see him soon. And it'd be even better if she could see him while he's out so she could also provide therapy. Your Honor, he could live at his mother and stepfather's home and just be able to pay the mortgage on his home under a tether and house arrest with only permission to work. And I'm hoping that
now the defense shifts into damage control mode. They're arguing he's not dangerous, not a flight risk, and even hinting outside influences may have affected his behavior. But once words like cult-like setting enter the conversation, you can almost feel everyone in the courtroom trying to process what they just heard.
that you'll consider that because a $200,000 bond for this situation may as well be no bond. And I think if you were willing to do 10%, it's something that could be done. It'd still be significant. He's certainly not a risk of flight since this is his only community and the only community he knows. And he has roots here. Further, as far as the danger, we can't only use the charge as a danger. He hasn't ever committed a crime in his life and never been in trouble. As a matter of fact, he was kind of enticed into a cult-like setting, Your Honor, that might have had something. I know that sounds strange, but Your Honor might hear about it. That may have influenced some behavior. Is all I can say about that now. But I just want that all considered, and I want to be able to get him some therapy.
Response.
Your Honor, I'm gonna object.
some
And then the
therapy.
prosecutor completely changes
Wrong.
the
Your
energy
Honor, I'm
in the
gonna object.
room.
In this case, we
Detailed
originally requested
allegations,
$250,000
repeated violence,
cash surety
threats
bond.
to
This case
kill, visible
involves
injuries.
an incident of domestic violence,
Prosecutors
which
know that
the previous
specifics
history
hit
here,
harder
there were
than
prior
general
unreported
accusations.
domestic violence
At this
situations.
point,
The
the
defendant was
judge
very
is no
controlling and
longer just
regularly
thinking
the
about
victim's keys
bond
and
money.
phone. One of the
He's
domestic
thinking
violence
about
incidents happened at
safety.
the house. In this case, we originally requested $250,000 cash surety bond. This case involves an incident of domestic violence in which the previous history here, there were prior unreported domestic violence situations. The defendant was very controlling and regularly took the victim's keys and phone. One of the domestic violence incident happened at the house and she could not leave without her help. In this incident, they had an argument and he took her phone and threw it. He then grabbed her and ripped her off the bed and punched her in the face. Later in that day, he saw an unsent message on her phone when she was asking a friend to come pick her up because of the incident and got mad. After he saw that, he then pulled her off the couch, sat on top of her, hit her arm with his legs, and headbutted her in the face 5 times. When this occurred, while this was going on, he threatened to cut off her head and kill her. After this assault, he then pointed a rifle at her and threatened to kill her. He had, and it's not just the report either, Your Honor. There are photos of her black eye that was severely swollen and bruised. She had bruising on her torso, her arms, her leg, a hemorrhage in her left eye, and it's significant swelling there as well. So I have severe safety concerns, given the facts of these cases and the significance of the seriousness of the charges and being American and not at this time.
Your Honor, let me just mention, she works with horses. Horses cause bruises and problems.
Pardon?
Horses.
This final exchange may have decided everything. The defense tries suggesting some injuries could have come from working with horses, but the judge instantly pushes back. You can hear the skepticism in real time. From that moment on, the court seemed focused on one thing only: whether the defendant posed a danger. And in the end, the bond reduction was denied.
Many horses she deals with in this setting where they were living and working. Horses.
So the bruises were from the horse?
I'm not saying that, Your Honor. I'm just saying there will be some bruises from riding horses. I'm sure of that.
Daughter rides horses. She didn't have many bruises like that.
Taking care of horses.
Never hemorrhage to the eye.
Your Honor, please forgive me. I don't mean to minimize the situation. I just want to point out that this is a person that works with horses, and having worked with horses in my life, I know that it's hard work.
So have I.
Okay.
Don't get a hemorrhage in the eye.
No, you do not.
Right.
Unless you're kicked. Right. I agree.
Right.
I agree.
I mean, and then everybody knows.
That's
So
right.
are you trying to indicate to this court that all of what's been described are from the horses?
No. I'm trying to say that she works with horses, and I don't know what's what yet. I know she has the eye injury. I've seen the photograph. It's bad, and it's sad. But I don't know all the circumstances. We will, and if in fact he's found over and found guilty, he will be punished. But we're not there yet. He's presumed innocent. Right now, we're at the point where we're trying to figure.
Presumed innocent, but what I'm hearing is that in my mind he poses a danger.
I think a 20%, 10% bond and house arrest and tether, would it be conditions reasonable to meet any danger that there would be? And he has people here, all 4 of them, to vouch for him. That's what we're looking for, conditions to make it reasonable, Your Honor. I think $200,000 is like a no bond. And you can get a bond in any case for that matter. So I'm just it, because there are circumstances, even just lower it somewhat, it would be helpful to the family if we could get him out and I could speak to him at his home or in my office, and he could have therapy and get ready for this. This is significant. We're not minimizing it. We understand that and appreciate your concerns.
Motion for bond reduction is denied. Bond will continue. Thank you.
Thank you.